NACDL is the association of the nation's criminal defense bar.
So I'm here to talk about ethical issues in street crime cases. Ethics is never an exciting topic, but I'm going to try to make it as exciting as we can in terms of what's going on. Now, in terms of defense attorneys have, I think, a special relationship with their client that gives us a gray area when it comes to ethics. We are required to zealously represent our clients. We are required to consult with the client. We are required to do as the client directs us in terms of certain things. As far as the model rules of professional responsibility is concerned, they say that we can consider moral, economic, social, and political factors when advising our clients. I have no idea what that means. In terms of the way that we advise our clients, I think that we evaluate the case, we look at what we know, and we give our clients as good a sense of what this case looks like as we can. I always try first to educate the clients about the process of the system. In other words, even if they've been in this 100 times, somebody may not have sat them down and say, this is how this works. This is what a trial looks like. This is what we're going to do the next time we go to court. I try to educate them and their family about the process of the trial so that they understand what to expect. And I think that's part of our job in terms of being an advisor. In addition, the American Bar Association says that we have standards that we have to use the best practices. And I think your best practice, as far as a criminal defense attorney is concerned, is to be able to zealously represent your client. Now, not everyone agrees with that recommendation in terms of defense function. And the loyalty to the client, the zealousness of the client, I think you can't be replaced. If you don't have a trusting relationship with your client by the time you're scheduled to either go to trial or resolve the case by way of plea, then the client has no faith in you. And so, of course, we have to talk to them. Of course, we have to get them to trust us. And how do we do that? How do we do that as zealous advocates? I think we do it by educating ourselves about the case, understanding who we're dealing with, and understanding what the limitations of the evidence are. You can't make the eyewitnesses go away. You can't make the DNA evidence disappear. But you can tell your clients how it is that you plan to attack that evidence. And you can be realistic with your clients in terms of what you think is going to happen as far as the case is concerned. We never, ever, ever guarantee an outcome. Even if we think we have there's no such thing as a slam dunk, but lots of clients will come to you and say, this is an easy case, this is a slam dunk. If I pay you X, can you do Y? If you represent me, can you guarantee me that I'm going to go home? And I actually always put in my fee agreement that I don't guarantee the outcome of anything. And I don't think ethically we can guarantee the outcome of anything. And I actually advise my clients, if you're sat before a lawyer who's telling you that he can guarantee you or she can guarantee you are not guilty, I'd get up and walk out. Because there's no way a lawyer knows what a jury is going to do or what a judge is going to do or how the witnesses are ultimately going to testify, even when you know the case as well as you do before you actually go to trial. And so I think it's very important to be realistic. You don't want people going to trial expecting a specific result when there's no way to guarantee that specific result. And I think ethically, we have an obligation to tell the clients what the limitations of our practice are. And so the language I like to use with clients is I'm going to do everything in my power to put you in the best possible position to succeed. But I can't guarantee it. That's all I can do. And that shows them a couple of things. It shows them you're willing to fight for them. It shows them that you're willing to do whatever you need to do in order to prepare for this case. And it shows them that you're in this together. And that's the thing that I think separates us from a lot of other types of lawyers, is that we have to believe in our clients. We have to believe that we have a shot, or we have no business walking into a trial. And that's really the bottom line. We have to believe there's some way to challenge the evidence. Even when there's a confession, even when there's DNA evidence, we have to believe. And I think our belief comes right back to my trial psychosis. Sometimes you get caught up in your defense so much that you don't really look at the big picture. And so what I like to do is what I call run my facts to people who are non-lawyers, people who could potentially be jurors. And so I have 5 sisters. They're all sick of my cases. But very often I will meet one of my 5 sisters for a drink and say, do you have 10 minutes so I can run this by you? And I'll run the facts of a case by them in the best possible light to the Commonwealth and say, this is what I'm dealing with here, what do you think? And I get from them a feedback of, just the average person. Well, wait a minute, what about this? And that feedback helps me then further hone my case. And I don't just stop at one of my sisters. I'm usually at least 2 or 3 of them into it before I actually go to trial. And then there's the friend set that you can also go to start running your facts and seeing what the reaction of these other people who don't know a thing about your client, who don't know any of the conversations you've had about your client, so that you can get a sense of what jurors are likely to see when they get into this. Because very often, by the time we go to trial, by the time we are ready to step into that courtroom, we know that case better than anyone. And we have to, because our reputation and our relationship with the jury depends on it. We have to know the facts better than anyone, we have to know the science better than anyone, and we have to know what we're dealing with better than anyone, because that's the only way that we can build credibility with the jury. And when your client sees how much you know, when your client sees how much you've looked into this case and that you know exactly where a witness is going to go and how you're going to deal with them, that builds the relationship between your client so that you can be that zealous advocate that everybody wants us to be. Now, in terms of continuing duties of defense counsel, we have a duty of loyalty, candor, and a duty to continually evaluate each decision that we make. Now, I don't know how you continually evaluate a decision that you've made. I think that we have a job, and our job is to evaluate the evidence and to call in the experts that we need to help us understand the evidence. And once we get that understanding, we have an obligation to go to our clients and to sit and explain to them in terms that they can understand what it is that they're up against. Here are the witnesses. Here's what they're going to say. Here is what the science says. You want me to raise a defense of mistaken identity, and there's DNA on one of the surviving victim's shoulders, and it's your DNA. It's really not a good defense, the mistaken identity. We can't win that, and let me tell you why. And very often, just explaining to a client in the most candid way that my job is to represent you. I'm trying to educate you as to what might happen as far as a trial is concerned. And so because I have a duty of loyalty, because I have a duty to be candor, and because I have to continually evaluate the evidence, I need to explain to you that this is not a workable defense. But we can't just leave it at that. If it's not a workable defense, we have to tell them what is. What can we attack? What does the case look like with this evidence in here? In slowly but surely, I think that the client will come around to the idea that, okay, maybe we can't say mistaken identity with DNA evidence on the victim's shoulder. Maybe that isn't the best defense. And maybe we can come up with a different defense. Maybe we can focus the evidence in a different way. And our duty, I think, in terms of doing this, is a different mission from what other types of attorneys have to do. Because we sometimes know our clients are guilty. And we sometimes know our clients were participated in some form of the crime, and we're not allowed to share that information with anyone, and we can't change what we're going to do as a result of it. Now, there are 2 different views of the ways that you can approach how you ethically represent clients. One is the adversarial approach, the other one is the truth-seeking approach. Now, the adversarial approach is just what I explained. You zealously advocate on behalf of your client through all lawful means. Now, lawful means is where the gray area comes in. But you zealously advocate for them. And that, I think, is the position of probably everyone in this room. But just so you know, ethically, there's another position, the truth-seeking position. And that says, basically, that you have to conform the truth-seeking even at the expense of the client. And I can't imagine any of us would do that, that we would conform what we're doing at the expense of a client. I don't know how you zealously represent a client with this approach, but I want everyone to be aware that certainly there are two separate approaches, the truth-seeking and the advocacy approach, that are both advocated by different ethics commissions throughout the country. Be aware of which one your BBO or your board of bar overseers complies with and which one they think is in place in your state, because you don't want to get in trouble. Now, as far as the biggest thing in terms of ethics I think that you can run into is the cooperating witness. What do you do ethically when you have a cooperating witness? How much of that information can you share, can you investigate, can you dig into without revealing the identity of the cooperating witness? Now, these witnesses are the most difficult, I think, from our perspective to deal with, especially if there's been anything like a joint defense agreement in place at the time that the case first starts out. When you find out that there is a cooperating witness or a cooperating co-defendant in the case, you know that that co-defendant has the same access to the same information that you've had this entire time. So what do? How do you start to prepare your defense with a cooperating witness? One of the things you have to be very careful about is whether or not there is a protective order in your case. Very often here in Massachusetts, the prosecutors will seek protective orders on straight assault and battery cases. It's ridiculous. We're not talking just about murders, we're not talking about kidnappings, but we're talking about district court cases where district attorneys' offices are seeking a protective order. And they're seeking a protective order to keep names of certain witnesses confidential, separate from the client. They don't want the client having access to a piece of paper that says, John Smith said, because they claim that sometime 10 years ago, some defendant ended up threatening a witness with some grand jury minutes or some statements, and therefore, from now on, we should all be precluded from sharing information with our client. The problem that I have with protective orders is it basically says to the client, I don't trust you enough. I'm asking you to trust me. I'm telling you that I'm going to be loyal to you. I'm telling you that anything you say to me is protected by the attorney-client privilege and I can't share it with anyone. But I know stuff that you can't know because some judge said, I can't trust you. And so just think about that statement for a minute when you agree to a protective order. Think about the message that you're sending to your client ethically in terms of what's happening. And what you're telling your client essentially is, the court said, I can't trust you. And the first thing the client's going to say is, how's the court going to know? How are they going to know if you just tell me what's going on? Here we are in this attorney room. There's not supposed to be any surveillance. Why can't you just tell me? It's a reasonable suggestion, but ethically, you can't. And I think here's where educating the client comes in. Here's where advocating for the client ethically comes in. And so when you're faced with one of these protective orders that's based on total BS, you fight it. You don't just agree to it, even temporarily. Because this whole school of thought, I want to get my hands on the evidence. And I want to get my hands on the evidence as quickly as I can. So let me temporarily agree to this protective order so that I can get the evidence, evaluate it, figure out what I need to do, hire my experts, go get my investigator involved. But here's what you do when you temporarily agree to the protective order. You tell the judge it's okay. You tell the judge that I'm not opposed to the whole idea of protective orders. I'm just opposed to it being permanent. And it makes it easier, in my opinion, for the prosecutor to get more of a permanent protective order. So be very careful. Challenge these protective orders, both because they impinge upon your attorney-client privilege, they impinge upon your relationship with your client, and I think they're unethical. How can you possibly have a relationship with a client where you're telling them, you need to trust me, you need to tell me everything, you need to believe that I'm not going to share it with anyone, but I can't share the knowledge that I have in my head about who's saying these things about you with you. It's a huge divide that we need to challenge and we need to get beyond. And so what I typically do when I see these protective orders is I flip right back to the back page where the affidavits are. And the affidavits about why they're saying this particular client needs a protective order. And very often it won't have anything to do with this client's case. It will be that 10-year-old case down the road where someone threatened a witness or a cooperating witness in that case, and therefore for the rest of eternity we should all have these protective orders. If there is a protective order, know that in Massachusetts you have a right to a hearing. You have a right to a hearing so that the Commonwealth has to prove what the basis for the protective order is and whether or not there's probable cause to issue such an order. And that has to be based on facts specific to your case. So when they attach these affidavits from other cases and ideas that somebody else threatened somebody, unless they can relate it back to your client, unless there's an affidavit associated with that with respect to your client, I think it's unethical to agree even temporarily to a protective order without advocating as hard and as long as you can. Because the other thing that it does when you advocate is it shows your client you're fighting for them. It shows your client that zealous representation that ethically you're required to do. And you're saying to him, I'm doing everything that I can to put aside this order because I don't think it's ethical. But once it's entered, I'm stuck. I can't really do much about it. So if the order does enter over your objection, the next thing I try to do is get it automatically lifted at a certain period prior to trial. Now, the normal language of these protective orders are, shall be in full force and effect except upon further order of the court. Always strike that out. There's no reason for that. When your client is going to trial, when he's getting ready for trial, he has the right to know who these witnesses are against him. He has the right to assist in his own defense. And he can't possibly do that if he can't understand all of the evidence against him. So what I always do routinely is add in a line, cross out that line that says it's never going to expire except by order of the court, and I add in a line that says, I start out with 6 months prior to trial. And that never works because it's too long. But at least you give yourself some leeway in terms of trying to negotiate. And I've got orders up to 4 months prior to trial, it automatically dissolves. So you don't have to go back to court, you don't have to go see a different judge, you don't have to explain everything all over again and give the Commonwealth another opportunity to tell a different judge how bad your client is and how much the witnesses need to be protected. It automatically expires, so think about that. And that language of automatically expires actually is your zealous representation of your client. It's your ethical duty, I think, to get these orders extinguished as quickly as you can if they've entered over your objection. So in terms of cooperating witnesses, now there's a theory of thought of how do you investigate a cooperating witness without breaching the confidentiality that the witness is actually cooperating. And so how do you do that? How do you go into a neighborhood or on a street corner and try to find out about this witness without actually obstructing justice, which is what none of us want to do. And so what I do generally is I try to find out as much about the witness as I can through social media. Most of these people will have Facebook accounts. Most of them will have some sort of Instagram accounts. Most of them will have public ways in which you can find out what they're all about. And so very often, when they're going to jump ship, those things get taken down by the police department. Their Facebook page gets taken down. Their Instagram page gets taken down. And so the earlier on in the investigation you can take screenshots of these, the better off you are. And so if you're in a co-defendant situation where you don't know if the co-defendant is going to jump the fence, I always at the very beginning go to the co-defendant's Facebook page. Start downloading who their contacts are. Start taking screenshots of anything that might be on there that if this guy jumps the fence 6 months from now, I'll have the opportunity to be able to try and litigate. And there's nothing wrong with that. You can't ethically contact a witness through Facebook or any social media without telling them who you are and who you represent. But there's nothing that stops you from seizing what's already out in the public. And anything that's on Facebook that's public is something that you can look at. And you don't have to worry about any ethics of it, and you don't have to worry about disclosing the identity of that informant in any way. So use that. If you find out that it's any type of gang testimony, what I typically like to do is look at the BRIC information. The BRIC information is the Boston Regional Intelligence Center. For those of you who practice in Boston, it is the epicenter of where all the intelligence for just Boston and the surrounding communities is held. It's not public. what the Commonwealth tries to say about the brick information is that it's the separate Chinese walled-off portion of the Boston Police Department. It's not. And I'm here to tell you it's absolutely not. Right now, they make us file Rule 17 motions to get access to this brick information. I can tell you that the brick information gets distributed at every roll call, to every gang unit in the state of Massachusetts on a daily basis. If they're using it to investigate your client in whatever crime they claim he used, you should be able to use it to investigate the defenses that you want to raise. And so very often what I do in these situations where I think there might be a gang-involved cooperating witness is I file a motion and say, I think you have this information under Rule 14, and Rule 14 is our Massachusetts rule of discovery. And I ask for it under Rule 14, and I usually attach some documentation that shows that this information is shared with all of the investigating officers and every single police officer on the force on a daily basis. And there are a bunch of different types of brick reports that go out every single day. And so I try to first get it under Rule 14 because I think it's in the possession of the Commonwealth. But there are some judges here in Massachusetts who will say, no, I believe the Chinese wall thing, and I won't give it to you in terms of Rule 14, but you can file a Rule 17 request for the public documents. That brings in the Boston Police Department legal department. They'll fight you tooth and nail. But very often, if you can get access to the brick information, it's going to give you all of the bad information about this witness, about this cooperating witness, without having to go out on the street corner and ask about what this witness is all about. And we have acknowledged that false snitch testimony in combination with prosecutorial misconduct are major factors in contributing to wrongful convictions. And in fact, prosecutors have no way of knowing whether or not these witnesses are telling the truth. They want someone to say, he did it and I saw him, or he confessed to me. That's what they want, because it helps them make their case. Their job is to seek justice, but we all know that's not what they do. They want their convictions. And so we need to keep reminding the jury that they have no way of knowing. They have no way of knowing whether or not these witnesses are actually being truthful. And the widespread use of informants in this process, I think, is being more and more challenged by us as a defense community based on the fact that wrongful convictions are happening based on the snitch testimony. So what do you do? How do you protect yourself from that type of evidence that might come down the pike? Well, there's a couple of things you can tell your client, again, in your role as a zealous advocate. Don't share your legal materials with anyone. All of these jailhouse attorneys that are telling you that they've been doing this for years and years and years, if they were that good, they'd be out already, wouldn't they? Why can't they get themselves out? And sometimes it's as simple as that to explain to them they can't be as good as they say they are because they're still in jail. So think about that. But don't share your legal material with anyone, because all you're doing is you're giving someone the opportunity to know details about your case. So if later on they want to jump the fence, they're going to say, geez, that wasn't public. How would he have found that out? And it's because your client shared the information because this guy said, I've gotten 10 different motions to suppress allowed, and I'm the one who can do this for you, and don't trust your lawyer, you should trust me. And somehow or other the client believes this person who he sees every day and shares his entire file with him. And lo and behold, 3 months before trial, that kid needs a break, and so he becomes a witness who's cooperating against your client, saying your client confessed to him. And how do you fight that at trial when he knows the details of the case that aren't public, when he knows the statements that were made, and he can concoct a story that's untruthful? What do you do about that as a defense attorney? And I think the inherent credibility issues of informants are something that we can always attack at trial. And so they're getting something in exchange for their testimony. They're not just coming up and saying, I'm doing this because it's the right thing to do. They're either in trouble themselves or they're trying to make some money. And we have to let the jurors know that they haven't come up on their own, that they're asking for something in exchange for their testimony. And most often they're getting it. And we all know that prosecutors have a role and a job to do, and that they're smart, and they're getting smarter every single year. And so they're not going to sit down with the cooperating witness and say, if you testify against me, I'm going to dismiss your homicide case or your drug case, your 15-year mandatory drug case, and you're going to get the street. Instead, they say, all I can say, with the big wink, all I can say is that we'll take your cooperation into consideration. And that's all I'm going to say. So that when you're cross-examined by someone like you say, what were you expecting? And then the rote is going to come out, that he's going to bring my cooperation to the attention of the district attorney. And that's really nothing in front of a jury. A jury goes, so what? So what, he's going to bring your cooperation to the attention of the jury? What does that mean? That doesn't mean you got anything in exchange for your cooperation. And so we have to do a better job, ethically, of being able to challenge these cooperating witnesses. They have little or nothing to lose and everything to gain. And we have to get that message across. They're in it for their own personal gain. They're in it because they want something. And the way that we can set them up on cross-examination is to prove just that they're in it for their own personal gain. And they're going to say, I don't know what my sentence is going to be. I have no idea what the Commonwealth's going to do. Well, then can't we bring in someone to say, you were facing 20 years. You don't think you're going to face 20 years, do you? And they'll say, no, I'm not going to face 20 years. Well, then they know that it's something less than 20 years. And so we have a job to do in terms of cross-examining these witnesses and staying within the bounds of ethics to do it. But we have to show that these witnesses have little or nothing to lose and everything to gain. Now, the informant and snitch cases, with respect to causing wrongful convictions, there are 48 cases. 48 cases where snitch or informant information caused a wrongful conviction that was later exonerated. That's a lot. Jurors should know this number. We should be able to tell them what happens with snitch information. We should be able to use this in motions in limine to say, Judge, I think I have a right to ask this witness or to ask the police prosecutor or the case agent in this case about the number of wrongful convictions that come from cooperating or snitch testimony. Because you're essentially buying the testimony. If you want to talk about ethics violations, I don't know how that's not an ethics violation. We don't get to buy the testimony. If we give the witness anything in exchange for their testimony, we're obligated to resolve it. But what do we have to offer? Nothing. We can't get them out of trouble. We can't reduce their charges. We can't bring them home to their families. And that's what they want. That's their goal. I don't want to serve time, and I want to be back with my girlfriend. We can't help them do that, but the Commonwealth can. So what we can do when we're dealing with snitch and cooperating testimony is educate the jury about the imbalance of power between the state agency or the Commonwealth and the defense. The best we can do for a witness who may have committed some sort of offense but is willing to be a defense witness is file a motion for defense witness immunity. Now, can I have a show of hands as to anyone who's ever been successful on defense witness immunity? Not that you haven't filed it. We've all filed them. But who's been successful in getting defense witness immunity? One.
Halfway.
Halfway. What does halfway mean? But if you think there are, 175 people in this room that litigate these cases all the time, there's one motion that gets allowed. We have to do a better job of educating judges and educating jurors just what effect this snitch testimony has. And that's part of our obligation to be zealous advocates in this case. Of the 111 death row exonerees since the reinstatement of the death penalty in 1970, 45% included false snitch testimony. That's a huge number, 45%, almost half. Don't you think that if the jurors knew these statistics, if they knew about these statistics, that they would evaluate that testimony of the cooperating witness differently? If they knew that almost half of the people who were on death row, of those 111 death row exonerees, almost half of them included snitch testimony? It's a powerful tool that only the Commonwealth or the government or the state has that's not available to us. It's an imbalance of power, and it results in wrongful convictions. And our job is to educate the judges about that, because we're not going to get our motions allowed unless they really understand what the data is behind this snitch-type testimony. Now, for the most part, most of the judges have been lawyers, and they know that everybody comes in at the end and decides to jump the fence for whatever reason, because they're incentivized. And we've always accepted the premise that it happens, it's part of trial procedure. My suggestion is we push back, and we say, no, unless you're going to level the playing field, unless you're going to let us do something that will incentivize our witnesses to come in, how do they get all of the cards? Especially when the data shows that they lead to wrongful convictions in almost half the time. How can that be and still be something that jurors get to consider? And I suggest it's because we need to challenge it better. We need to get these statistics before judges and look at recent studies of what's happening with this snitch testimony. That's the way that we challenge it, I think, ethically. Now, we just talked about them having all of the resources at their disposal. The other thing that is the imbalance that I always tried to bring out at trial is the resources that the government has versus the resources that we have. Not only can they promise informants and cooperating witnesses leniency, but they have the entire state at their disposal. They have the state police, the local police, the crime lab, the FBI. Everybody will come and help them. And it's us and our investigator and maybe our ID expert, depending on the case. And that's it. The imbalance of power there is something that jurors should consider. It's something that we should bring to the forefront, especially when they're dealing with this type of snitch testimony, because it creates this unequal power balance. And jurors don't like it. Jurors don't like when the playing field isn't level, and it's not. So it's our job to educate everybody about the unequal playing field. So there are some things that are in effect that throughout the country that we're trying to put a limit on how much money an informant can be paid. We're trying to limit the information that an informant gives. And let me just give you one quick sort of war story about an informant that just blew up an entire case out of Brockton in Massachusetts. I was trying the case. There was an informant who claimed, a snitch who claimed that my client had confessed to him. Now, the client had been in jail 4 years awaiting trial, which is a whole other story, but 4 years awaiting trial. And I had given him instructions to not talk to any of his friends, not be on the phone with anyone. The only people I let visit him was his mother, his father, and his brother, and he had no other visitors. He broke up with his girlfriend, none of his friends contacted him, and I gave him specific instructions not to discuss the case unless I was sitting next to him. And then I went and I talked to his family, and I said, listen, I don't want you asking him questions about this case. If I'm, on any recorded line, on any visit, in any letter, I don't want any of that to happen. I don't want them to be able to come in later on and say he confessed to somebody. I want him to not have had a single word said about this case the whole time that he's locked up. And that's essentially what this kid did. He followed my advice. He did what I asked him to do. He didn't talk to a soul, broke up with his girlfriend, did everything I asked him to do in order to put himself in the best possible position to succeed. And even still, they come up with an informant who said, when my guy was walking around the yard, he found this kid that he never knew, and all of a sudden, in the course of one day, because there was no other footage that they had ever been together, and there was no footage this day because it got lost, but they claimed that during this one day, although they had no prior relationship, didn't know anyone on the street, my client walked up to him and confessed. I mean, it's a completely implausible story. But you start thinking, why is this kid telling the story? What's in it for him? And so I start digging in terms of what's in it for him, and I find out that he had this very, very serious case in Brockton County where he had kidnapped somebody and put lighter fluid on them and threatened to light them on fire, and ended up with an 18-month suspended sentence. Can't be. So I go to dig a little deeper and say, how could this have happened? And I even go to try to meet with the informant to see if he's willing to speak to me. And he says, no. And then ultimately, he claims he was threatened, so he gets out of jail. And now he's on the street and everything changes. And so he comes into court and he gives them the testimony that they're looking for in terms of, this is my client at a preliminary hearing. And then the trial rolls around, and he's got a completely different attitude. And I'm thinking, what's going on here? He had already testified at the co-defendants trial. He did very well. I watched him. He came across as a credible witness. But now he's got this attitude. So I go in again, and I say, mind if we have a conversation, me and my investigator, can we sit down and talk to you? And he says, yeah, I'd be willing to talk to you. I said, okay, great. What is it? What's the problem? Why are you so pissed off? And he said, well, last time I testified at the last trial, the Commonwealth paid me what I would have been paid if I had gone to work every one of the days that I was here for 2 weeks. And now they're saying they won't do it because I got pissed off when they served me again, and I threatened to kill the case agent. Really? Okay. How did I not get that? So, of course, I go insane, and I go into the judge and say, this is just what I learned, and blah, 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 fully expecting the Commonwealth to say, she's out of her mind. This guy's lying to her. And instead, I get a police report that says he did threaten the case agent. He threatened to kill him if he came anywhere near him with another subpoena, and that he wasn't coming to Brockton unless they gave him, I think he said, $5,000. And they said no, they weren't going to give him $5,000. And they dragged him here anyhow. And apparently, he took a little hissy fit over in the DA's office and broke a lamp. And the first assistant over there got pretty mad at him and decided that he wasn't going to pay him at all and pissed the kid off to the point where he was willing to cooperate and tell us what happened. So, of course, he gets on the stand, and I get from him everything that happened and the fact that they don't produce this report till the middle of trial and that they had paid him for his testimony. And he ultimately says he doesn't ever remember having the conversation with my client. But he does remember the prosecutors telling him that if he didn't say he had it, that they would screw him on that underlying case where he poured lighter fluid all over the victim. Now, you can't get any better than that. So ultimately, the case wound its way through the system, and I can tell you that the Commonwealth ultimately dismissed the case against my client. It was a double homicide, and it got dismissed because there was such a nightmare with the informants. But it doesn't end there. It gets worse for this kid because the Commonwealth was so pissed off that he had not performed as he was supposed to, as they had told him to, that they ended up, we find out probably a month and a half, 2 months after the case gets dismissed, that this kid gets arrested. And it ends up in the local Brockton enterprise that he gets arrested. And I'm thinking, he's not even supposed to be in Brockton. What the hell did he get arrested for? So I go just because I'm curious, and I get a copy of the police report. And they arrest him because when he was testifying against my client, he had an illegal firearm on him that the state police took from him every day and put it in their secure container outside of the courthouse and then gave it back to him at the end of his testimony every single day. And when they were pissed off that he didn't perform in the way he was supposed to, they charged him with the illegal possession of that firearm. So this kid, and generally I never stick up for informants, but this kid who now is charged with a criminal offense, which the police were complicit in when he was willing to tell the story that they wanted him to tell, and when he didn't, now all of a sudden all bets are off. So I get in touch with his lawyer, and I say, listen, there's more to this story. This kid is telling the truth. And you know what he tells me? Oh my God, the judge just sent him to Bridgewater State Hospital because they thought he was crazy. Because they thought when he said, the police gave me permission to take that firearm, that he was nuts. So this kid ends up in Bridgewater for 30 days because he tells the judge that this is a giant mistake, that he was cooperating with the Commonwealth, that they're just pissed off at him because he didn't perform the way they wanted to, and now they're charging him with this crime. And so the Commonwealth thinks they're screwing everybody, and especially this kid, by putting him in Bridgewater. But what happens is the kid actually ends up talking to a therapist and tells the therapist that 2 of the DAs prosecuting my case told him to lie in a homicide case. Told him to lie. And so that report that gets then sent to the court saying, I'm a little concerned about this because he's saying that these prosecutors told him to lie, that all comes to light. And ultimately another case that my client had pending, where I had threatened to call this witness to show what the Commonwealth was capable of doing, ended up getting dismissed. But that's what happens when the Commonwealth doesn't get their way. That's how quickly these snitches can change on a dime. And so I guess the moral of the story is that, when you get that gut sense that the snitch isn't all the way over the fence, that his leg is hanging for some reason, You need to go in. You need to have that conversation, and you need to see if they're willing to sit and talk to you. And very often, if they're on the street, they want to appear as if they're trying to help the defendant. And so they'll have that conversation with you. As long as you have your investigator there and you're just getting the facts and you're trying to figure out why this kid cooperated in the first place, there's nothing ethically wrong with that type of investigation. Nothing ethically wrong. There's a huge difference between that and walking down to the corner and saying, do you know witness X? And give me the dirt on him because he's cooperating in a double homicide that I have. I agree that would be unethical. But these ways of getting directly to the informant, if the informant is willing to speak to you, very often you'll be surprised at the number of times where they want to make it appear as if they're trying to help the defendant or that they had no choice but to testify against the defendant. And there's always that little nugget. Yes? At that time, he wasn't charged with the gun charge. So this was before. If you had an attorney on the gun charge, you have to talk to the attorney. You can't go and talk to him without talking to his lawyer. Ever. I don't think you can talk to a client who's represented by counsel without talking to his lawyer. But any good lawyer is going to say, yeah, no. You're not getting anywhere near my client. This is a deal that I have in place, and I'm going to, their job is to protect their client. But at this point in time, in this particular litigation, because he had been on board and he had just testified at the co-defendant's trial, he didn't have a lawyer. They hadn't charged him at that point. I'm the one who reached out to his lawyer and said, this kid isn't lying. Like, I'm telling you, he's telling the truth. And like I said, I don't very often advocate, but there are these crazy, crazy situations where you have to look into what's going on as far as these cooperating witnesses are concerned, because it happens more often than you think. Yes? So first of all, what happened to the prosecutors? Nothing. Nothing happened to them. Not even a report to the BBO as a result of what they did. And second, in terms of could you use that witness? In every single case that I have in Brockton, he ends up on my witness list, every single time. And I always disclose all of the stuff that they gave me that they did for him, especially in a case where we have a witness who says there was a confession by my client or who says that they heard my client do something or say something, because the whole office is dirty as far as Brockton is concerned. And I think that that's relevant. I think the jury should understand and be able to see that. So yes, I always put them on the witness list. I always add that discovery. But what the Commonwealth has done recently in the most recent case is to try to move to impound the materials because I'm handing them out like lollipops. And they want to stop it because they don't want this to happen. And so they've moved to, in the latest case that I have, they've moved to impound that information. And my position with Judge Chin was, it's already out there. Like, you can't take it back at this point. And they're the ones who were thinking in the beginning they were screwing me by giving it to me. So it is what it is. It's they didn't disclose this information. It has nothing to do with me. Once I know it, you can't burden me with not being able to share it with anyone. Because thankfully, in that case, there wasn't any type of confidentiality agreement. There wasn't any type of protective order. So all of that information is free to the public. Anyone wants it, please call me. Happy to divulge it. And in terms of how we get those statistics before the jury, the way that I've done it, there isn't such a motion, because I think if you filed a motion, they'd say no. But the way that I've done it is I've always asked the person who took the statement from the cooperating witness whether or not he's aware of these statistics. And you have the big picture of the statistics right in your hand, and you go flying up to the witness stand to shove it in his face. And even if it doesn't get admitted, even by the time it gets objected to, if it gets objected to, the jury got it. Jury understands it. So do I know a way pre-trial to get it admitted? No. I don't know a way pre-trial to get it admitted, but I think that it's a question you can ask and a question you should ask in a situation where you have snitch testimony, because the jury has a right to know. Now, is there a question of whether or not you should go to sidebar and ask the judge for permission before you do it? I think it depends on where you are in the midst of the cross-examination. It depends on the judge. It depends on whether or not you've been told in advance you can't go down that road. So if you've been told no, absolutely you can't go down that road, you would have to ask for permission and find a relevant reason to raise it. But if you haven't been told no, you can go to sidebar and explain your theory of why you thought this was relevant, and I think that it's solid. I think it's solid in terms of educating even this witness. He believes, because most of these cops are going to believe everything that the snitch is telling them, because they're feeding the information to them. And what do you know about this guy? And do you know anything about the white van? And do you know anything about this? It's the way in which they're asking the questions that's suggesting the answers to the witness before the witness even says boo. And so it's important when you're cross-examining that type of snitch that you get the exact words that they used when they were interviewing him. So it isn't a situation where they're sitting back saying, tell us what you know about Mr. Defendant. That very rarely happens. It will be a situation where, okay, so before we got on tape, you told me blah, 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 blah. And that's their whole case. And then the witness says yes. And then the cop says, well, let's back up and take this, piece by piece. And they break down exactly what they just told the witness into statement after statement after statement. And very often, if you look at the snitch testimony enough, you'll see that they're just saying, yep, yes, and agreeing, but not necessarily offering any type of explanation, not necessarily offering any bits or facts that come from their own indication of what was going on, because very often they're fed the information from the police. And that's what jurors need to understand about this type of testimony, so it doesn't lead to a wrongful conviction. So, advising clients to cooperate. So, is there an ethical obligation to advise clients about the benefits of cooperation, about the risks of cooperation, whether or not to cooperate, whether or not to not cooperate? I think the answer is yes. In advising the clients as to what their options are, you have to advise them that they certainly have an option to cooperate with the Commonwealth if that's what they choose to do, or cooperate with the government if that's what they choose to do. Here in Boston, there's a lot of judges, at least in the federal side, who will give benefit to what they call first in the door. The guy who jumps the fence first gets the best deal. And there are specific judges in Boston who are known to give the best deal to the first guy who jumps. And so do you have an ethical obligation to your client to inform him of that? I think you do. I think there's no way that you could be able to give your client all of his options and not talk about cooperation. Now, you'll have some clients who will say, that's not me, I'll never cooperate. I have a tattoo that says I'll never tell. Those are usually the ones that always jump first. But in any event, whether or not they decide after they've been educated whether they want to jump the fence or they don't want to jump the fence, that's up to them. But what our obligation is to give them the option. Nobody likes to represent somebody who is cooperating. All of us like the fight, but if it's in your client's best interest, if he's dead in the water, if there's no way out, if it's on video, if he can't get around it, if the quantity is too high in the federal court, or he's smiling at the camera as he's walking out of the 7-Eleven, those are tough cases. And you have to be realistic with your client in terms of what their options for success at trial are. And so if the only way out is to cooperate, then I think you have to tell them. In terms of not cooperating, I don't think you can tell a client not to cooperate. That's not your decision. That's their decision. They decide whether or not they're going to cooperate. You can't be one of those people who say, don't cooperate with them because they're going to screw you in the end. I think you can advise them that lots of people do get screwed in the end. You can't guarantee what they're going to do for you ultimately. If they feel like screwing you, they can. You can educate them in that way, but you can't tell them not to cooperate because that would be unethical. That's their decision. They get to make it, but we are obligated to fully inform them of what their options are. And if there is an option to cooperate, there's always an option to cooperate. The Commonwealth is always looking for someone to say, he did it. And so we have to be mindful of that and make sure that our clients are educated about that option. And I typically, when I do educate my clients about that option, I typically take very good notes about what they say to me, about whether or not they want to or don't want to cooperate, because very often in the beginning of the case, nobody wants to cooperate. Everyone thinks they can win. And then as the evidence starts piling up and the DNA evidence comes in and the videos come in, it gets a little more difficult. And so I like to have that conversation probably 2 or 3 times. At the very beginning, to let them know that it's an option. Once what I call the physical evidence, the CSI stuff comes in, I like to be able to explain that to clients and then explain again, completely your option. I'm not ever going to a DA to explore a plea unless my client tells me that that's what they want me to do. Because I think once the district attorney's office knows that you're willing to resolve it, you become less of a threat to them. The threat to them is in going to trial because it's a crapshoot. You don't know what's going to happen at trial. But once you lose that edge, I think, if you go too early when your client isn't committed to cooperating. So certainly educate the client about cooperating, explain what the options are in terms of cooperating, and then your job is to protect the client. So we always have to be open to the possibility of negotiated dispositions. and we have to tell them about the benefits of cooperation. That's our continuing duty as defense attorneys. Now, when we are negotiating the terms of cooperation with either the government or the state, depending on where you are, we have to make sure that the role that they want the client to play is clear. We have to make sure that the client is protected, and any incentives that the client gets are built into that agreement. So in this case, we want to make sure that everyone is present, and counsel certainly is present during any communications with the client. If the client is going to cooperate, we should be sending a letter to the DA's office, to the cop, saying, I represent him. Do not talk to him without me being right there. Because if you don't send that letter, they'll swing by and have a conversation with him, either at his house or outside his work, ask him questions, and you have no control over it because you're not aware of it. So even though your client has decided to cooperate, he's still entitled to that attorney-client privilege and the zealous representation that we're all supposed to do. So in terms of what your insistence is, I think we all need to insist of being present during all communications with our client. Then there's immunity agreements. Is there a possibility of getting your client immunity? Let's figure out what he did. Let's figure out how bad they need him. And so in terms of ethical considerations, if there's immunity, there's 3 different types of immunity for your clients: transactional, use, and derivative. And you should know the difference between all of them before you start negotiating on behalf of your client, so that you can make sure you get the gold standard. So if you're lucky enough to get transactional immunity, it's sort of queen for the day. Whatever your client's done, they can't use against them. It's the best type of immunity you could ever get. It's very rarely given out. If you know about 8 different bodies, maybe they go there for you. If you don't, chances are it's either going to be use immunity, which prohibits the direct use of the person's words against them, but it does not prevent the prosecutors from using information to develop leads to other witnesses or evidence that may be used against the client. So basically, what they tell them in that proffer session won't be used directly against them, but you're giving the state or the government the opportunity to make derivative use of whatever your client tells them to build different cases against different people, and sometimes against your client, depending on what he said. And then there's derivative use immunity, which protects against the indirect use of information provided, bars the prosecution from using either the actual words or information provided by the witness, or any information or evidence derived as a consequence of the compelled information. So derivative use, can't use it at all. Now, ethical considerations. Immunity offered by a prosecutor in one jurisdiction generally doesn't cover the client's actions in another jurisdiction. Immunity in federal court generally doesn't cover the client's actions in state court. So if your client's jumping that fence, it's our job to make sure that he's protected or she's protected both in the state and the federal court. So if the feds want your client bad enough, they'll make the call to the state agency, to the DA's office, and say, will you guys give him immunity as well? He's doing X, Y, and Z for us. But it's our job to make sure once he's made that decision or she's made that decision to jump, that we have to protect them with everything that we have, so that when they decide that they're going to do this, that the government can't come back or the state can't come back and somehow hurt our client. So that's what we're talking about in terms of ethical considerations. Typically, there is a proffer letter. A proffer letter sort of outlines what the government's willing to do for your client, what your client is willing to do for the government, and any benefits that your client might get as a result of this proffer letter. So it's going to put all the information that the prosecution anticipates that your client will negotiate for, and the degree of immunity that is authorized by whatever state agency. It should all be in the proffer letter. In terms of debriefing the client, very often when your client decides to cooperate, they're going to want to sit down with him. They're going to bring in all the case agents, they're going to bring in the DA's office, they're going to bring in everyone to sit down and ask him a bunch of questions. And so we as attorneys can't ever let that happen until we've sat down with our client and asked them the questions that we know they're going to ask. And one of the most important things that we have to get across to our client is that once you decide to jump the fence, you don't have the option of protecting anyone, including your own mother. You don't have that option anymore. You have to be truthful, and you have to tell them everything. You can't leave anything out. Because if you do, they can void the entire agreement, and then you're in more trouble than you would have been if you decided not to cooperate. So the idea that they have to be truthful. It's our job, I think, to test the truth of what they want to tell the government. So sit down with them, debrief them in the same way you know the government is going to debrief them, so that they're ready to be able to have that conversation. And stop them when it doesn't make any sense. And say, wait a minute. You just told me that you were on the corner of this street and this street, and you said that you talked to this kid, but I have these records in front of me that says there's no such call. And you have to get that specific with them in terms of the story that they want to tell. And so I always let them tell the story that they think they want to tell, and then I tell them what I see the problems are with that story. And I'm not saying you're lying, I'm just telling you these are the problems that if I was a prosecutor, I would ask you about from that story. And I'll go through each individual problem that I see in that recitation of what he says the facts are, so that he's prepared when he's dealing with the government about what they're going to ask him for. We just talked about the truth and what obligations we have to tell the truth and getting that information across to your client as quickly as you can. And then the last thing I'm going to talk about is breach, because I think I'm out of time. If your client breaches the agreement, he's entitled to a hearing to determine that there actually was a breach. So make sure that if your client screws up and doesn't say everything he knows and tries to protect someone, that there isn't just a voiding of the agreement, that you insist on a hearing so you can, again, try to protect your client's rights. With that, I'm told I'm out of time.